500,000 Americans are dead, not from a war and not in some distant country, in kitchens and bedrooms across the United States. The agency tasked with preventing exactly this held evidence that could have stopped it. They possessed internal documents, shipping data, and an airtight case for the largest pharmaceutical prosecution in American history. And then the case disappeared. The crisis began in 1995 with the release of OxyContin. Purdue Pharma marketed the drug by claiming its time-release formula prevented the euphoric spike that causes physical dependence. Internal company documents later showed Purdue's own scientists knew that claim was false. Purdue deployed a massive sales force to convince doctors that this highly addictive narcotic was safe. They handed out free starter packs and assured over 40,000 physicians that the risk of addiction in legitimate pain patients was less than 1%. By laundering a debunked marketing claim through the credibility of the medical establishment, Purdue effectively turned ordinary doctors' offices into the starting points for a national public health massacre. In the early 2000s, a team of DEA investigators began tracking severe anomalies in the prescription data flowing into quiet, rural communities. The math made no sense. Single pharmacies in towns of only 3,000 people were taking delivery of hundreds of thousands of opioid pills every year. This map shows the volume of opioids moving into West Virginia. Over a decade, pharmaceutical distributors shipped 9 billion pills into a state with a population of only 1.8 million people. That volume far exceeds any legitimate medical demand. The investigators recognized they were looking at a highly organized, heavily protected supply pipeline. Pipelines of this magnitude require a regulatory vacuum to function. The investigators were about to realize that the law had been engineered to protect the very system they were trying to dismantle. The DEA possesses a powerful regulatory weapon called an immediate suspension order, or ISO. It allows the agency to instantly freeze a company's legal registration to ship drugs to protect public health. Using concrete shipping records, the DEA issued immediate suspension orders against major distributors like McKesson for moving massive volumes of narcotics into known pill mills. But the suspensions were blocked. The pharmaceutical distributors challenged the orders using legal teams composed of former DEA attorneys, people who knew the agency's internal processes better than the investigators themselves. This chart tracks the migration of enforcement expertise. Over a decade, more than 50 DEA investigators and attorneys left the agency to work directly for the pharmaceutical companies they were previously investigating. These former officials weaponized their knowledge of DEA evidentiary thresholds. They used their insight to perfectly paralyze the agency's enforcement actions, arguing that the agency was overstepping its authority. By hiring the same attorneys who had written the DEA's playbook, the distributors gained the legal blueprints required to dismantle the agency's enforcement power from the outside. While those cases stalled in court, the pharmaceutical lobby invested $2.5 billion to secure a legislative solution in Washington, D.C. In 2016, Congress passed the Ensuring Patient Access and Effective Drug Enforcement Act. Not a single member of Congress voted against it. This graphic shows the legislative trick. The law changed the standard to freeze drug shipments from proving imminent danger to immediate threat. The old standard allowed preemptive action. The new language required proving specific harm within a defined timeline, a threshold functionally impossible to meet. The new standard effectively paralyzed the agency's ability to intervene early, leaving the DEA to respond only after addiction had already ravaged a community. The United States Congress passed a law, drafted with the help of pharmaceutical lobbyists, that revoked the DEA's power to stop the overdose crisis while the robbery was still in progress. Unable to freeze shipments after 2016, the DEA shifted its strategy. Instead of pursuing criminal prosecutions, the agency resorted to delayed financial settlements. This chart compares those settlement fines to corporate earnings. McKesson paid a $150 million penalty, set against their $200 billion in annual revenue. That fine registers as a minor corporate expense. These financial agreements also acted as legal armor. The companies admitted no criminal wrongdoing, ensuring that no executive faced the possibility of prison time. Richard Sackler, the man who drove the aggressive marketing strategy for OxyContin, remains wealthy and free. while families across the country mourned children who died because of his company's choices. The American justice system treated the deaths of 500,000 citizens as a negotiable business dispute, rather than a mass crime. A tiny crack in this armor appeared in 2023, when federal prosecutors in West Virginia finally unsealed criminal indictments against specific distributor executives. While these indictments represent a step toward justice, they are only a microscopic fraction of the accountability owed to the public. The core architecture of inaction remains operational today. The lobbying infrastructure, the revolving door, and the compromised 2016 legislation stay fully intact. That 500,000 death toll functions as a ledger of specific, protected choices made by people in rooms where power and money outweighed the public interest. The system did not fail. It worked exactly as designed, proving that in America, power protects itself.